Our topic is, what is title insurance? It is a 2-hour elective course approved by the South Carolina Real Estate Commission. The number is CEE 3250. I am Liz Loadholt. I am the instructor for this course. You can see here that I am certified for South Carolina LLR education instructor. I am also a certified distance education instructor. So we are going to look at title insurance today. First of all, let's go over a few instructions. If you have not already registered, you must complete the registration form in order to receive credit from LLR. That registration form is on the same page where this video was located. That plus the handouts is on that page. In your handouts, there will be 55 very good reasons to obtain title insurance. And there's samples of exception Schedule B for actual title insurance policy. And it shows exceptions. We'll be talking about that. There's also a sheet from Chicago Title that compares standard policy with enhanced policy. Let's take a look at what you can expect from this class. There will be an hour video, and then a 15-minute discussion with your instructor, and then a final test, which you will need to have a passing grade of 70 in order to get credit for this class. And you must have the 15-minute discussion with your instructor to get credit for this class. So let's look at what is actually expected of you for this discussion with the instructor. At the end of the course, you will need to email the instructor at the email given here with the information. We want to know the most important reason you feel owner's title insurance is critical. The instructor must email you back that this criteria has been satisfied. So you will need to email the instructor to have an email discussion about why you think owner's title insurance is critical. The email address that you will use is aoschoolre@gmail.com. That's aoschoolre@gmail.com. Next, with the rules of the class. We need to focus on the material at hand and enjoy the journey. Next thing is I want you to stop and think, is title insurance important or not? From what you know about title insurance or what you've heard about title insurance, do you think it's important? Since lenders do require title insurance to cover their loan amount, do you feel that owner's title insurance is important? Think about it. I'm going to give you a few minutes to ponder this. When I feel like you've had adequate time to really think about what your feelings are on title insurance, the next slide will appear. Hopefully, you've come to some decisions for yourself. If you're a little unsure of how important you think it is, hopefully this course will help you make that decision. Just as a side note, there are actually about 45 different title insurance underwriters out there in the country. People like Chicago Title, Stewart, First American Title, Alliance, just to name a few. Hopefully, after this course, you will know title insurance better, and you'll feel that not only is it important, but it is critical. Okay, let's look at some terms. Title. What is a title? For real estate purposes, the title refers to ownership of the property, meaning that you have the right to use the property. It may be a partial interest in the property, or it may be full. However, because you have title, you can access the land and potentially modify it if you see fit. That's what a title is. Next, bad title. One that does not grant ownership. It does not grant ownership to its holder due to unsatisfied legal or financial problems. That is considered a bad title. If you're like me, you've heard attorneys talking about a cloud on the title. What in the world does that mean? A cloud on the title, any document or encumbrance that may adversely affect the title. Cloud on the title is any document, claim, unreleased lien, or encumbrance that might invalidate or impair a title to real estate or make the title doubtful. Clouds on the title are usually discovered during the title search. Then a clear title is a title without any kind of impairment or liens. It's absolutely clear. It's what we all look for and hope for. So what are encumbrances? It's a claim against title impacting the use of the property, like mortgages, easements, tax liens. Can also be personal as opposed to real estate. Maybe a plumber that did some work for you and didn't get paid what he thought he should have gotten paid. He puts a lien on the property. That would be an encumbrance. Now let's look at the definition of title insurance. This is taken from Investopedia. It says title insurance is a form of indemnity insurance that protects a holder from financial loss sustained from defects in a title to property. Title insurance is a form of indemnity insurance that provides the holder from financial loss sustained from defects in a title on the property. So what this is saying is that it protects the person who has title insurance from any financial loss coming from any problem with the title. What is title insurance? It's insurance against defects in the title or deed that have already occurred but are not yet known. Things that have happened on the title that have occurred but not yet known. These defects may be against the property or the property owner. Some examples of these defects may be errors in public records, maybe unknown liens, illegal deeds, heirs, forgeries, unknown easements, which brings me to a story about that. An attorney was telling me about a client of hers that had a drainage ditch under the house. She all of a sudden saw a lot of problems with water and things under the house. She had bought the house roughly a year before from a good friend of hers that owned it, so she trusted the situation, and this buyer was a realtor herself. She said there was a drainage ditch under the house, but when she bought the house, she did not know that. The seller before her did not know that. But when they had all this water accumulating under the house, they started investigating, and what they found was not pretty. What they found was a drainage ditch. It was a sewer line planted basically under the house. The legal description made no mention of it. The survey made no mention of it. So nobody knew it was there. After a lot of investigation, they found that the town owned it, and the town did not know it was there. It had been put there years and years before, and then the house was built. So it had been there a long time. Luckily, it had not given anybody in trouble until that point. But it started to be really bad. It was rotting out all under the house. It was just a mess. The town did do the repair work under the house, but then they wanted to get this owner to give them an easement under the house. And the reason the attorney was calling me was to ask me what I thought that would do to the value of the house and how would that affect the resale. Well, in my opinion, it would decrease the value of the property and it would definitely affect the resale. Who wants an easement, a drainage easement, a sewer line under their house if they know about it? No one. My suggestion was the town should buy the house. I actually don't know what ended up happening with that story, but that's an example of a defect, of that lien would be a defect in the title. What does it cover? What does title insurance cover? A loan policy only protects the lender. Only protects the lender. The owner's policy protects the owner. So as we go through this course, you'll really understand why owners need their own coverage. We're going to be delving more deeply into the loan policies and the owner's policies and the difference, and then the two types of those that we're going to be discussing. So just hang on. Title insurance really dates back to the 1800s, and the efforts to insure titles were primarily organized by and for the benefit of attorneys who wanted protection from errors that they might make in the interpretation of abstracts. Over time, title insurance became available to anyone wishing to purchase it, not just attorneys. The basic principle of title insurance is similar to any form of insurance. Many persons pay a small amount of money into an insurance pool that is then available if one of them should suffer a loss. This is the same way that regular insurance works. Homeowners insurance, automobile insurance, it all works the same way, same principle. So title insurance covers claims made as a result of improper indexing in the county records. So any improper indexing would be covered. Claims caused by missed liens, judgments, mortgages of record. So if there's anything the attorney misses when they do the title work, like liens, judgments, mortgages, that would be covered. Claims made by missing heirs, and we do have that. Claims resulting from forgery or fraud. And there's approximately 51 other reasons, and in your handouts there is the sheet, 55 very good reasons to obtain title insurance. Please be sure to review this sheet and to have these in your bucket of knowledge so that when you're talking to these buyers, you can recommend insurance for all these different reasons. Title insurance for all these different reasons. Owner's title. Some other reasons why one might want to get title insurance. Some of the reasons to obtain it: false personating of the true owner of the land and other instruments. And you might think that doesn't happen, but it does happen. We actually had it happen on the Isle of Palms, and we'll talk about that a little bit more later. Deeds by persons of unsound mind. Deed by minors. Deed by aliens. Children living at date of will, but not mentioned in the will. Deed from a convicted felon. Erroneous reports furnished by tax officials, but not binding on municipalities. That's an interesting one, and we actually had that happen as well. I can tell you about that later as well. Let's take a few minutes right now for you to stop and look at that 55 reasons for title insurance. Look over it. Interesting things. And you just might find a need when you're working with buyers to have this in front of you, to be able to convince them to get owner's title insurance. There will be silence while you have time to look over the sheet. When I feel like you've had enough time, the next slide will appear. Hopefully, in reviewing this sheet, you have found many things that you can talk to your buyers about, many different possibilities of what can go wrong and why they would need owner's title insurance. Title insurance makes title to the land much more marketable. In nearly all real estate transactions, the seller agrees to deliver marketable title to the buyer. As a matter of fact, our SCR 310, subject to financing contract, calls for the seller to convey a marketable title with a properly recorded general warranty deed. You hear folks talk about marketable title and insurable title. So what's the difference? Let's take a look. A marketable title is one that is reasonably free of litigation. So a marketable title would be one without defect, whereas an insurable title would be a title with defects, but defects that a title insurance company is willing to insure over based on the facts. Let's look at a couple of examples. Say you're closing in 2020 on a property, and there's an open mortgage from 2005 from a couple of owners ago. The title is unmarketable, but an underwriter may determine the title is insurable. It is unmarketable because the mortgage has never been satisfied according to the records. The question becomes, is your buyer willing to accept a title like this that is not marketable but insurable as an individual decision? We had a situation where when the title search was done by the attorney, they found an open mortgage, and it was from 2 sellers ago. A mortgage had never been satisfied, and when they started digging into it, we found that the seller that had that open mortgage, the person who had the mortgage on the property, had passed away. So no one knew if the mortgage had really been satisfied or not. We just knew that it was not recorded as satisfied. No insurance company, no insurance underwriter would insure that title in that situation. I know you're curious how that ended up. Well, it ended up that the estate of the person holding the mortgage finally agreed to put money in escrow. I don't remember exactly, but I think there's a number of years they had to go through some process. And so the estate put money up until that process was taken care of so that the property could close. But all of that took months, even doing that. And once the estate put money in escrow, a title insurance company was willing to insure the title. What about heirs property scenario? There's a deed and to Dad in the 1930s. The next deed is a deed out from a daughter in the 1980s with a good chain of title since that time. This title is unmarketable, but an underwriter may determine that title is insurable. It is unmarketable because there was never a deed from the dad to the daughter. One deed was to the dad in the 1930s, and the next deed was from the daughter to someone else in the 1980s. There was missing that deed from the dad to the daughter. So it's not marketable, it's a defect. But an insurance company may decide to insure over that. Another case may be a bad deed. A deed from the 1970s has no witnesses, so it failed to properly convey title. But the chain is good since that time. The title is unmarketable, but an title insurance company may determine that it's insurable. So you can see in each of these examples that I have just given that there are defects in the title because of either a deed not being witnessed, or not even being a deed from the dad to the daughter, or an open mortgage that has never been satisfied according to the records. In the case of these open mortgages, a lot of times the mortgages were satisfied, they were just never recorded as being satisfied. That is a problem. And believe it or not, we see a good bit of that. Let's look at some benefits for an owner. Coverage to protect the owner's equity against unforeseen. Remember, we said title insurance is for things that have happened but not yet known. So it protects the owner equity against the unforeseen. We'll look at some examples. False personation of the true owner of the land. The seller at closing isn't really the seller. Do attorneys check IDs? I believe they do now. I don't know of any that wouldn't check an ID, especially if they don't know them personally. One of our agents actually had something like this happen. At the closing table, husband and wife supposedly were there to sign, and when the attorney checked the ID for the wife, it wasn't the wife, it was the girlfriend. Interesting. Undisclosed heirs, which later surfaced to reclaim their land. We've seen that happen as well. Deeds by persons apparently single, but actually married. Then the wife shows up wanting her house back. Title insurance would cover that if you had owner's title insurance. The Catawba Indian claim in Rock Hill, South Carolina, threatened 61,767 landowners and 144,000 acres. It was settled in 1993 in return for $30 million from the federal government and $20 million from South Carolina and local public and private sources. The Catawbas will relinquish chain to 144,000 acres surrounding and including this picturesque college town of Rock Hill, South Carolina, 35 miles south of Charlotte, North Carolina. At the time had 42,000 people. The land now includes such valuable property as Winthrop College and Heritage USA, the Christian theme park built by the disgraced evangelist Jim Baker. So 1992, 1993 was a tough town up around Rock Hill. Those owners that had owner's title insurance were able to sell those homes, and those without were just stuck. So owner's title insurance was very, very important to those guys. There are two types of title insurance, and later we'll see that there's two types of insurance policies, but there are two types of title insurance. There is lender and there is owner. The lender gives protection to the lender who is giving the loan. The owner gives protection to the borrower. So if the lender is required, if you're getting a loan on a property, if you're getting a mortgage, the lender is going to require title insurance. And it has always baffled me as to why an owner would think it's not important to get owner's insurance. If they stop and think about it, the lender will not let you close without title insurance. So if they think it's that important to protect their interest, why would an owner not want to protect their own interests? Let's look at the differences in lender and owner policies. An owner policy is good for the full amount of coverage stated on the policy for as long as uninsured heirs have an interest in the property. Whereas the lender policy protects only for the amount owed on the mortgage loan. The coverage on this policy declines and finally terminates when the loan is fully repaid. So the owner's title policy is good for the full amount of the policy, whereas the lender is only amount of the mortgage. Also, the lender policy terminates when the loan is paid off. And so if the same people still own it, they're left with no title insurance at that point. Whereas the owner's title policy is good as long as insured or the heirs have an interest in that property. The owner's policy does make exceptions for claims to ownership that could have been determined by the physical inspection of the property, whereas the lender policy does not make exception for claims to ownership that could have been determined by the physical inspection of the property. We'll talk more about exceptions later, but what this is saying is if, for example, a survey might be an exception on the title policy if an owner does not get a survey. We'll talk more about that as we go along. Whereas on the lender's policy, the survey would not be an exception for the lender's policy. And an owner's title policy is not assignable, whereas a lender's title policy is assignable to subsequent holders of the same loan. So if the mortgage gets sold to another lender, then it would be assigned to that lender. Where if the owner's title policy, if the owner sells a house, the title policy goes away. It cannot be assigned to the new purchaser. Those are the main differences between the owner title policy and the lender title policy. Now that we have looked at the two different types of title insurance, we're going to look at the types of title insurance policies. We have the standard and we have the enhanced. So the types of title insurance, we have lenders and owners. The type of title insurance policies, standard and enhanced. Let's look at the standard first. The standard title insurance covers just the basics and includes protection against the following potential claims against your property: claims by other parties that they own the property, mistakes made in public record, previously unknown heirs claiming an interest in the property, fraud, forgery, other wrongdoings, liens against your property, lack of a legal right of access to your property. The standard is what's pretty much passed along unless someone asks for the enhanced. The enhanced title insurance policy, it includes all the coverages of the basic title insurance and added protection against a few more risks. So with the enhanced, you get all the basics that the standard policy covers, plus you get extras. The enhanced includes certain zoning and building permit issues, including violations of recorded covenants and restrictions. The enhanced insurance policy also covers encroachment of structures onto your property or of your buildings onto a neighbor's property. And we see this a good bit too. So if you had standard policy, it would not cover that, but enhanced would. Enhanced also covers subdivision violations, supplemental tax assessments. The enhanced owner's policy is not available for vacant land or some other situations, non-1 to 4 family residential properties. It really is strictly for residential properties. The enhanced policy costs 20% more than a standard policy, but it's well worth it. Both policy types have a one-time premium. Again, the enhanced policy is not available for vacant land. It's not available for commercial properties, not available for any LLCs, corporations, trusts, etc. An enhanced policy is only for residential. A very important part of the enhanced policy is that it covers up to 150% of the value for appreciation. The standard policy does not give you any appreciation in your property. Enhanced policy gives you up to 150% of the value for your appreciation. And if you're in a good, stable market and one that's increasing, the values are increasing, what a great advantage. Well worth the 20% extra that you pay for the policy at the time you obtain it. Enhanced policies are not for lenders, it's only for the owner. Let's look at this chart that compares the enhanced with the standard. Let's look at the coverage. Inflation coverage up to 150% of the original policy. Standard offer that? No. Enhanced policy offer that? Yes. Coverage for the heirs and beneficiaries upon the insured's death. Standard cover that? No. Enhanced? Yes. Discriminatory covenants. Standard cover that? No. Enhanced? Yes. Unrecorded easements. Standard cover that? No. The enhanced policy cover that? Yes. This next one, I have a correction. Survey coverage without a survey for certain covered risk. It means that would be an exception. The survey would be an exception on the insurance policy if someone did not get a survey. Standard? No, but they do. On a standard policy is covered. I apologize for the mistake in the graph, but it was there. I do need to make the correction that lender's policy will cover a survey without a survey being done. However, the enhanced policy will not cover a survey. So someone buying a house, getting a new property, needs to have a survey in order to keep the survey from being an exception on the enhanced policy. About coverage for access based on legal right. Yes, they both cover that, the enhanced and the standard. Damage to existing structure due to maintenance or use of easement affecting your land. Deductible and limits apply to this. Standard does not cover that, but enhanced does, realizing that there are some limits that apply to this. How about failure to obtain a building permit by the previous owner? Standard does not cover that, but enhanced does. And we actually had a situation like that. And our owner had actually bought the enhanced policy, which was very good. So you can see from our discussion and our chart, the enhanced policy is a jewel. Everyone should get enhanced policy. It's more than worth the 20% extra that you pay at the time that the title policy is purchased. Quite often, agents will say, why does title insurance cost one thing with one attorney and something else with a different attorney? The state regulates the price on title insurance, so you would think they'd be the same. The difference is normally that one attorney is quoting the enhanced policy and one is quoting the standard policy. Because again, the enhanced does cost 20% more. But remember, it also gives the owner up to 150% of the original value for appreciation. Please don't use title insurance as a cure-all. It is not a cure-all. Title insurance is not perfect. It's not perfect. The owner or the lender must experience title failure before any title insurance will provide any relief. They have to experience a failure first. There may be protection, but only after the property owner experiences the problem. So it is not a cure-all. Most title insurance policies have exceptions. Unfortunately, buyers are usually not told about the exceptions. I've been to several closings and I have never heard, not once, an attorney explain the exceptions on the title insurance. It's a little scary to me. But a lot of the policies do have exceptions. As a matter of fact, most title policies have exceptions. In your handout, you'll find a sample of some exceptions. This particular handout has a lot of exceptions, so you can browse through it and see what I'm talking about. For example, it says liens for real estate taxes, assessments, and other charges imposed by a governmental authority that are not shown as existing liens by its records. So it's saying that if there's something out there that is not showing on the records, they're not going to insure it. And you'll see that it's quite a few easements to different things, like the telephone, South Carolina Power Company. Things like that are exceptions. In other words, the title insurance company is not insuring those things. Tax deeds cannot be insured. You must clear the title first. People buy property at tax sales and think they can sell it. They have to clear the title. Well, they may be able to sell it, but they're not going to get title insurance on it until that title is cleared. Attorneys have E&O insurance, so why does my buyer need title insurance? I've had this question asked many times. There's a reason. Maybe the attorney has retired and gone out of business. His law practice is out of business. Maybe the attorney passed away. Maybe the attorney went bankrupt. I've known of situations where the attorney went out of business. He was disbarred. I know of situations where the attorney passed away. These are situations where title insurance would be critical. Their E&O is not going to help anymore. Let's look at what title insurance costs. It's showing here it's $125 for the title insurance binder. That does vary between attorneys. I've seen that as high as $200, $250. I've seen it as low as $100. It is typically in that range. Then there's a $15 to $35 insured closing protection letter. That varies between attorneys as well. Then we have the owner's title policy premium. It's a sliding scale that can calculate that. It can be calculated by going to the www.ratecalculator.fnf.com. Again, for those who are interested in going to the website, www.ratecalculator.fnf.com. Title policy premiums have a base price of $100 minimum. The loan policy premium is based on simultaneous issue charge of $100 when paired with an owner's title policy. So if you're getting a mortgage, the lender, the mortgage company, is going to require that you have a lender policy. And if you get the owner's policy at the same time, it saves a lot of money and it's very inexpensive to get them together. An interesting tidbit, at least I find it interesting, the commission on title insurance in South Carolina is 60%. So when you have a closing in South Carolina and your buyer is getting title insurance, you can know that the title insurance agency through which they got the insurance is getting that 60% commission. Most of the time, the closing attorney has their own title insurance agency. This commission does vary from state to state. I know in Florida, the commission is 90%, so it's different in different states, but in South Carolina, it's 60%. Next, let's take a look at reissue credit. It's one of my favorite things to talk about. What is reissue credit? It's simply a way to provide the buyer with a discounted title insurance premium. Who doesn't like to get a discount? How does a buyer benefit? It reduces the title insurance premium up to 50% discount. That's huge. It can reduce the title search fee depending on the attorney. It also depends on the attorney whether or not you can get reissue credit. Some attorneys will say that unless they did the original closing, that I cannot give reissue credit. The state does not say that, but the attorneys have that way. That's their policy, so it depends on the attorney. If the attorney who's going to be handling the closing is willing to give reissue credit, here's what you have to do. You must provide a copy of the property owner's previous title policy. It must have been issued within the last 10 years. Any kind of previous title policy would do, owners or lenders. But you have to have a previous title policy that is 10 years or younger. It's the only way to get the reissue credit if you have a title policy that has been issued within the last 10 years. And as we said, any type of policy will do. It can be a lender's policy or the owner's policy. The owner's policy is ideal. It may qualify for a reduced title search. It may qualify for a reduced title search. If the policy, the previous policy from the current or previous owner, is less than 2 years old, notify the attorney as soon as possible in order to receive the best discount on the title search, if the attorney is willing to discount the title search. Not all attorneys are willing to do that, and this is only good on the owner's policy if the attorney is willing to give that credit. On a loan policy, it is okay for reissue credit, but the full title search is required for the loan policy. We're going to look at a sample loan policy. This is a sample of a loan policy for the lender. You can see it's kind of small for you to look at, but at the top you see some numbers in black. That is the policy number. This particular one is a Chicago Title insurance policy. Chicago Title is the insurance underwriter. If you remember in the beginning, I talked about the different types of title insurance underwriters that are out there. There are over 40 different title insurance underwriters. An underwriter is just like any other insurance underwriter. You have Allstate, you have State Farm, you have Geico, and regular insurance. And title insurance, you have Chicago Title, you have Stewart, those kind of agencies or companies. What we're looking at here is actually the jacket for the policy. Then we look at Schedule A of the policy. This is where it tells you what is insured and what it's covering. It looks like this. You can see at the top, if you can see it, it says Schedule A. Then this page is Schedule B. This is really the exceptions to the insurance policy. They're listed here as exceptions. Remember, we talked about the exceptions earlier. This particular policy does not have a lot of exceptions. Remember, in the handout, you have that 2 pages of exceptions for you to read through and see what can be considered as exceptions. That was Schedule B, and this is Schedule B. So now, let's get back to reissue credit and talk about it a little bit more. How much does it save my client? Reissue credit can save up to 50% of the premium. Remember, the minimum premium is $100. Reduced title search can save as much as 50% or more. The total savings may vary depending on the closing attorney. Some attorneys will not do reduced title search, and remember, you have to have a previous title policy that is 2 years or younger to get the reduced title search. And remember, some attorneys will not provide reissue credit, so you can't ever tell your buyers it's always going to be there. But it is certainly something that you need to be aware of, and make your buyers aware of it as well. Advance notice is critical for reissue credit. Remember, a previous owner's policy may qualify for both a reduced title search and reissue credit if the attorney knows in advance and if that particular attorney does agree for reissue credit and for reissue on the title search as well. Why not write it in your contract? Seller to provide a copy of a current or past title policy for the subject property. That would be an easy way to get a copy of the title policy and hopefully save your buyers some money. The possibility of reissue credit for your buyers is an important reason to select the attorney at the contract signing. Then you can make sure to contact that attorney and make sure that they will agree to reissue credit if the title policy on the current house is 10 years or younger. Here's another thought. Use title insurance to sell your listings. Ask your seller for a copy of their title policy. Remember, it must have been issued within the last 10 years in order to save the potential buyer some money. I should say, potentially save them some money, depending on the attorney and if the attorney is willing to reissue credit for the title policy. Remember, any kind of title policy will do. The owner's policy qualifies for reduced title search in some cases. The loan or lender policy is okay for reissue credit, but the full title search must be required if it's a lender policy. Let me correct what I said. Any kind of policy will qualify for a reduced title search. It qualifies, but whether or not the attorney is going to allow it is a different story. Add remarks in the MLS or on your flyers and on your flyers. Want to save dollars in closing costs? Ask about title insurance reissue credit. It's available in this home. Do not guarantee reissue credit. Do not. Do not guarantee reduced title search. Do not do that. You cannot guarantee either one of these because you do not know if the closing attorney is going to be willing to cooperate with that. It's just a really good thing if it's possible. Now we're going to start looking at scenarios, some things that really happen with title insurance, just other things that make you aware and make you want to make sure your buyer has title insurance. Let's look at the first scenario. Buyer closes on a property. He does obtain owner's title insurance in addition to the lender title insurance. He does. The new buyer gets a tax bill next year and is billed over $3,000 for the previous owner's taxes. The buyer calls the closing attorney, very upset. The closing attorney pulls his file and determines that Charleston County had indeed told them that the taxes had been paid. So that's what the attorney went on. That's all he had to go on. Attorneys are just relying on what the county tells them. When the attorney called the county to ask them about this, the county's attitude was, everybody makes a mistake. They said that the taxes were due and this buyer, new owner, owed them. Thank goodness this buyer had gotten owner's title insurance because the title insurance stepped in and paid the back taxes. Had he not gotten owner's title insurance, he would have been in trouble because he would have had to pay the $3,000. Be sure that your buyer gets owner's title insurance. Looking at our second scenario, Mr. Smith owns a lot on Front Beach. Mr. Smith lives in New York. Joe Bunch decides to put a for sale sign on the lot and sell the lot for an unbelievably low price. Now, Mr. Smith owns a lot, but Joe Bunch puts a sign on it to sell it. The buyer puts a contract in on the lot and proceeds to go to closing, remembering that Mr. Smith owns the lot and Mr. Smith knows nothing about this lot being sold. Mr. Smith, who actually owns the lot, has no idea that all this is going on. Luckily, the closing attorney saw something in the title search that alerted them to the fact that the proposed seller was indeed not the actual seller. I don't know what it was that triggered it, but thank goodness something did. The closing attorney had the police at the closing when proposed seller showed up. Had this purchaser actually closed on the lot, it would have been a mess when the real seller discovered this had happened. The purchaser would have needed owner's title insurance to be covered. Just bring up an interesting point to remind you that this owner would not have been able to get enhanced policy, but the standard policy would have taken care of that. Because remember, enhanced is only good for residential, not vacant land or commercial or LLCs or corporations. Scenario 3, owner owns a very large warehouse for which he paid $2,600,000 2 years ago. When he purchased it, there was no mention of any issue with the title. Actually, with the seller before this owner, there was not a mention of the road being an issue or anything wrong with the title. There is an abandoned road behind the warehouse. One half of the road is actually on the property with the warehouse. One half of the road is not on the property itself. Now that the owner is selling, he has secured a buyer. It appears that this abandoned road is an issue. Apparently, the road was never officially abandoned by the county. The new buyer's attorney found the cloud on the title. It was missed by both previous attorneys. Now there's an issue that has to be resolved. I'm sure you're wondering, did the current owner buy owner's title insurance when he bought it? Good question for you. Did he? Could he? Yes, he did. If you will remember, he could not get enhanced owner's title policy because this is a commercial building, but he did buy the standard policy. So he had owner coverage, which thank goodness he did, because now he needs it. All right, moving on, scenario number 4. Buyer signs a contract to purchase a property. The closing is scheduled. Buyers and sellers show up for closing, but when the attorney asks the sellers for proof of identity, the wife was not really the wife, but a girlfriend. Had this closed, the real wife would have had a claim and could have put a lien on the property, and I would hope that these buyers would have obtained owner's title insurance, because if not, they would be up the creek without a paddle. Can you just imagine being at a closing like that and that happening in front of you? Bizarre. A lot of things happen at the closing, but this kind of thing is unusual. Thank goodness. I'm pretty sure most all attorneys now do check for ID before they start signing any papers. There's so much craziness going on in the world. They have to check and make sure who the people are. Scenario number 5. Buyer closed on a home. 4 months later, the buyer gets served with papers that he owes a builder $44,000. Imagine the shock. It was not new construction. Our buyer did not deal with a builder for the seller, so he could not figure out what was going on. As it turns out, the builder claims the seller of the home owed him $44,000, and since it was not paid at closing, the buyer owes him the money. This is crazy, right? It actually happened, though. Apparently, the seller, when our buyer bought it, that seller had had a builder build the house for them, and apparently still owed the builder some money. The mistake the builder made is he didn't put a lien on the property, so there was no way to force it to be collected at the closing. Of course, our buyer was not aware of any of this going on. There was nothing on the title when the title search was done prior to closing. There had been no liens filed on the property. The builder is saying that there was a verbal agreement with the seller that he would be paid at the closing. Thankfully, our buyer had gotten owner's title insurance at the closing. The whole situation was turned over to the title insurance company, and they took care of it completely. Our buyer did not have to worry about it at all after the big scare at the beginning of receiving the papers. Thank goodness he got owner's title insurance. I have to go again and say owner's title insurance, very important. Now moving on, scenario number 6. A developer is selling 15 lots. Now you got to follow along with me here. Someone buys lot number 1 and puts a mobile home. No new survey. They did not get a new survey, which we always recommend people do. Someone buys lot number 14 and builds a home. They did not get a new survey either. They used the builder's survey. Okay, someone buys lot 15 and puts a mobile home. No new survey, using the builder's survey. Then somebody comes along to buy lot 16 and they get a survey. And when their survey is done, it shows that the mobile home on lot 15 is actually on lot 16. What a mess. As it turns out, all of the mobile homes and the stick-built home were all on the wrong lots. Title insurance stepped in and saved the deal. Title insurance ended up buying another lot to get everybody straight. This took quite a while to accomplish all of this. Had these folks not gotten owner's title insurance, they would have been in big trouble. 2 morals of this story. 1, you should always recommend your buyers get surveys, and they should always get owner's title insurance. 2, big deal. This next slide is just interesting. I thought it was interesting, something I found when I was doing some research. Did you know this little girl could own your home, evict you, and throw out all of your stuff? In the state of Florida, if a person lives in a home and has a minor child, that child inherits the house. What if the previous homeowner had a girlfriend you didn't know about, and the girlfriend had a baby with the previous owner? That child owns the home, not you. Very weird. The previous homeowner's girlfriend's baby is not going to show up in public records on a title search, but she could evict you. Let me remind you that this was in Florida, not South Carolina. Okay, the big reminder. Now that you finish the video section, you must now email your instructor. The email address is aoschoolre@gmail.com. Remember, you email your instructor about what you think, your feeling, why is owner's title insurance critical, and have that discussion with your instructor so that then you can get the approval of the instructor that you finish the class and take the test. I like to end all of my classes with one of my favorite sayings: nothing is a problem until it's a problem. Just think about that. What a perfect course for this to apply to. With the title insurance, you can get a title search, you can close on a property, and never have a problem. Not buy title insurance, not buy owner's title insurance, and never have a problem. You could. And then again, you may have a problem. Nothing's a problem until it's a problem.